Lords, it's a pleasure to follow two of the House's acknowledged experts in this area of the impact of AI, and I rise to speak to my own amendments 323B, and also note that I attach my name to two of the amendments in the name of the Noble Lord Holmes of Richmond, 294 and 298. Now, my 323B, to start off with, is actually quite a modest step. It's calling for a review within 12 months to be published. Now, in saying that, I wanted to thank the ministers for having a meeting prior to the discussion of these amendments. I appreciated that, very much appreciated that discussion. But I think the time for talk is over. The time for action is now. 12 months is still too short, but it seemed like the best that I could reasonably put the time frame on for this call of review of electronic monitoring of workers in the workplace. And this picks up some points made by the Noble Lord Holmes. And it also, crucially, I think, points to the need to look around the world and see what else is happening where we can learn from what's happened in other places. Because the companies selling these systems are absolutely global, giant multinational companies. The companies deploying these systems are giant multinational companies in many cases. And it's important that we actually, rather than try and pick this off ourselves, look around the world to say we want to be leaders in creating a different kind of model of how workers can be protected. And I'll just point, Noble Lords, to the Australian Parliament Employment Committee, which did actually do a report on digital transformation. And that was in the context of a strike last year at the Woolworths, and Woolworths is the largest supermarket chain in Australia with 32% share of the market. The Woolworths Melbourne South Regional Distribution Centre, which had a 17-day strike with very significant impacts. And this was workers who had simply had enough. They were working with the United Workers Union, and the place of the union in this, I think, is very interesting. And they said, we are sick of every second of every move of us, our work being monitored, of us being driven to work harder and harder, not being replaced by robots, but being forced to work like robots, like we were a machine, when we are, of course, a human being of flesh and blood. And I can't help but draw a contrast to the situation of what I describe as the great parasite Amazon, which of course very famously deploys many of the same practices, but has been extremely resistant to union involvement. And so we have seen union activities, and I point Noble Lords back to point out how long these issues have been going on, and back to 2019, when the GMB union actually had a Prime Day action to complain about what was already happening to workers and the health and safety issues that were rising. And of course the situation has only got much worse since then. So that's the issue of the monitoring of workers while they're working. But what about the other two amendments to which I've attached my name, which address issues of people being employed or able to stay employed? And I do want to point your Lordship's committee to the case, particularly very much a landmark case of Pa Adrissa Manjang, who was an Uber Eats worker who faced repeated difficulties with verification checks that used AI and automated processes. He was permanently suspended from the platform after a series of failed facial recognition checks because of, quote, continued mismatches. He told the company, your algorithm by the looks of things is racist, and that indeed was what the Employment Tribunal found. And funding for this case was provided by the Equality and Human Rights Commission and the App Drivers and Couriers Union. To quote the lawyer representing Manjang, it was among the first to consider AI and automated decision-making in the context of the work and the potential for unfairness and discrimination. And I think it's telling that that was the first case, because it's actually relatively clear-cut. It's relatively easy to identify what's going on here. It's pretty obvious. But there are many cases where it may not be so obvious. I point to some research from Natalie Shared from the University of Melbourne, who cites one of her research participants, a career coach, explaining that one of his neurodiverse clients, a top student in his university course, had, after many, many job applications, been unable to get through personality assessments. The career coach believes the student's atypical answers resulted in low scores, and so the student did not progress through the process. But that, of course, is very difficult to identify and the kind of thing that would be very difficult to take a legal case on. And I point to the case in the US, and this is an ongoing case, so these at the moment are only claims. But it's against a financial software company that claimed that a third-party, that used a third-party vendor screening software. The claim was that this discriminated against deaf and non-white individuals. It was an AI-based video interview program, something that might be a little strange to members of your Lordship's House, but when I talk to young people out in our workplace today seeking, they're very, very familiar with. Non-white, one of these cases here was an Inuit person who spoke with an accent, and deaf or hard of hearing speakers. In this case, the employee requested human-generated captioning as an accommodation. That was denied by the software, not by a person, by the software. And then the interview was rejected, this applicant, on the basis of her communication style. The machine, I keep coming back to this in your Lordship's House, this is not intelligence. It is crunching big data. It does not have any actual understanding of the real situation of the person before us. And if we think about, in California, the consumer watchdog CalMatters has been highlighting, and of course in the US, tips are a terribly important part of many restaurant workers' work. They point to the case of food service industry workers, and the scheduling software assigns people to shifts. Some shifts are highly lucrative, some shifts are much less lucrative. Now, some of the things the algorithm might be looking at is whether you take breaks, how fast you turned over a table, which of course is not going to be in your control because it depends on the customers you get. Where you live might be used in the allocation of shifts, but all of this is invisible to workers, effectively impossible to challenge. Now, I was actually going to quote, again highlighting the fact how long this has been an issue, the General Secretary of the TUC in 2021. However, since I see the noble lady herself is now in her place, and I suspect she might be going to stand up, I won't quote the noble lady there, but I will quote, to finish, from this year, the Unite General Secretary Sharon Graham, who said that many of the people she represents are feeling alienated and demotivated by the way AI is impacting on their workplaces, impacting on their work, impacting on their chances of being advanced within their workplace. And I guess I've stressed both the internationalness and the length of time this has been an issue, because when we hear very often from the government on all of these issues about so-called artificial intelligence, we sort of hear we've got to wait to see what happens. Well, I'm afraid that's not good enough and not an appropriate circumstance. How these tools are deployed, where they're used, where they're not used, these are matters of political decision-making. We can make choices, we can make laws. They are not independent actors outside our control, and neither should be the giant companies that largely promulgate them. We need to, dare I coin a phrase, take back control and say there are places where this is inappropriate or it needs to be extremely tightly controlled.
Yeah.
My Lords, following the invitation from Lady Bennett, yes, I do feel obliged to say you'll be relieved to hear some very brief words on this group of amendments. I was at the helm of the TUC when we produced an AI manifesto for workers, and that manifesto was AI positive and optimistic about the potential for AI to help us create more satisfying work for workers and also to boost productivity if we share those gains fairly. But it was also realistic, because the real experience of workers at the sharp end in terms of technology more generally, is that it's often been used to drive, for example, the gig economy that this bill proudly is looking to tackle in terms of insecurity and low pay. Workers also experience really oppressive surveillance, with Amazon being right at the top of the rogue gallery in that respect. And of course, technologies have been developed such as facial recognition that bake in race discrimination. So of course workers are right to be wary and right to be concerned. And that's why one of the key demands in that AI manifesto was exactly as the Noble Lord has talked about before, the right to a human review when it comes to decisions about hire and fire. This is, as I see it, a very fundamental human right, that you should have that right to a human review. And critically, it called for a voice for workers in agreeing new technology, including AI, agreements, so that workers' concerns are addressed directly and agreements are made with employers about how it's introduced and used. I just wonder, given that there, in a very welcome sense, there has been such a broad interest and concern expressed in this short debate, whether the Minister can reassure us that we will be addressing not just the problems like the gig economy that we saw growing in the 20th century, but the new challenges of the 21st century, where workers urgently need protection.
My Lords, can I start by thanking very much indeed my noble friend, the Lord Holmes of Richmond, the noble Lord, Lord Clement Jones, and the noble Baroness Lady Bennet of Manor Castle for their amendments in this group, and for their very thoughtful introductions and contribution to what is clearly a vital and timely discussion around the future of artificial intelligence in the workplace. So turning first to the amendments tabled by the noble Lord, Lord Clement Jones, specifically 148, 149 and 150. These proposals seek to define AI systems in statute, mandate workplace AI risk and impact assessments, and I believe the correct pronunciation is WARIA. I think I heard that earlier. I wasn't sure how to say it. And impose statutory consultation duties on employers prior to the deployment of such systems. My Lords, in my respectful opinion, these measures go a bit too far at this stage. So, to begin with the proposed definition of an AI system, I fully accept the need for clarity in legislation, but the definition offered here is overly expansive and risks capturing a vast range of tools, from predictive text and email sorting to payroll systems and basic data analytics. Technology evolves rapidly, and any attempt to lock such a broad and fluid concept into rigid statutory language at this point, we think, risks hindering innovation and forcing employers into compliance regimes for systems that may pose no meaningful risk at all. On the proposal for WARIAs, Workplace AI Risk and Impact Assessments, the intentions behind this are understandable. However, the execution here reads a little bit more like a blueprint for a full-scale regulatory regime rather than a light-touch safeguard. Employers would be expected to carry out detailed documentation, consult staff, assess and monitor impacts on mental health, contractual terms, pay and more, and then repeat this process at least annually or upon any system change. And that is no small task, my Lords. For large employers, it might be possible, but for SMEs, this would surely be burdensome and in many cases entirely unworkable. So our concern is not with the principle of transparency or fairness, but with the disproportionate bureaucratic weight these provisions would place on businesses, particularly those outside the technology sector who simply may not have the capacity or the technical knowledge to meet such a standard. The third proposal, which is a statutory duty to consult employees or trade unions at least 1 month before deploying AI systems, again assumes a degree of foresight and technical certainty that may not always exist in practice. The development and use of AI systems is often iterative, and definitions, use cases and impacts evolve over time. Requiring formal consultation at every turn risks paralysing technological progress and may well deter even cautious adoption of beneficial systems. My Lords, I recognise that these amendments are rooted in a desire to protect workers and uphold ethical standards, but we do have to resist the temptation to reach immediately for sweeping, front-loaded legislation in a domain that's still very much in its infancy, Regulation in this space, as I'm sure all noble lords would agree, must be agile, proportionate, and grounded in practical reality. We are now entering a new phase where AI is no longer confined to research labs or boardrooms. It's appearing across ordinary workplaces, public and private alike. There are tremendous opportunities to improve productivity, to streamline operations, to foster collaboration between human workers and AI tools. Yet we do think that many of the proposals in this group, including those seen elsewhere, such as the mandatory appointment of AI officers, rights to personalised algorithmic explanations, opt-in clauses and statutory principles of fairness and explainability, share a common shortcoming, and that is that they attempt to legislate about highly technical and fast-evolving systems with a degree of rigidity that may prove counterproductive. My lords, on these benches, we share the government's ambitions to become a world leader in this space, and therefore we must remain mindful of all of those factors, as well as existing protections. Several of these proposals risk duplicating duties already present under UK GDPR, data protection law, and various existing employment safeguards. The creation of overlapping, inconsistent, or duplicative regimes could confuse employers and regulators alike, and all while doing little to prevent truly harmful practices. So, my lords, while we acknowledge all of the opportunities that potentially are offered by AI, we must also remain vigilant to the risks posed by AI, including algorithmic bias, opacity in decision-making, which we've heard a lot about, and the misuse of personal data. But that vigilance must be coupled with regulatory restraint. We ought to be cautious to not impose premature, overly burdensome rules that stifle innovation and overwhelm well-intentioned employers, particularly in low-risk use cases, such as things like rota planning or document handling or payroll automation. There is also, of course, a much bigger issue here, and that is regulatory overlap, which needs to be addressed on a cross-government basis, in fact, probably a cross-societal basis, to be perfectly honest. And that's something that we all have to get involved with at some point, because I think my noble friend Lord Holmes raised an incredibly important point. This is clearly a subject that demands considerable attention. So I would hope that the government will bring all of these subjects together fairly soon, because as we keep seeing, indeed yesterday in this House, the way it's happening at the moment is to promote a piecemeal approach, which is definitely suboptimal. I believe my noble friend called that a strange situation, and I have to agree. My lords, where guidance, voluntary standards and sector-specific codes can offer a more proportionate route, we should favour them over legislative prescription. Our shared goal should be to create and foster trust, to responsibility and innovation, and not to create barriers that could slow progress and reduce opportunity for both business and workers. Having said that, of course, to reiterate the point, I totally understand the intention behind all of these amendments, but I hope that we've made our position clear. Thank you.
Yeah.
My Lords, I'd like to thank the noble Lords Lord Clement Jones for his amendment 148, 149 and 150, the noble Lord Holmes of Richmond for his amendments 289, 290, 291, 292, 293, 294, 295, 296, 298, 315 and 316, and Baroness Bennett for her amendment 323B. And I thank them for raising and generating a very important debate around these issues. And I also thank my noble friend Baroness O'Grady for her wise words on this issue. If I take the amendments in turn, then I'd first like to turn to the noble Lord Clement Jones amendments 148, 149 and 150. These seek to introduce mandatory AI risk assessments in the workplace where there are significant impacts on workers, and place a requirement on employers to consult with employees and trade union representatives before implementing AI systems that may significantly impact employment rights and conditions. And I also thank the noble Lord Clement Jones for his amendments 315 and 316, which establish an independent commission on AI in the workplace and a project to investigate the potential challenges posed by the algorithmic allocation of work by employers. And in addition, I thank the noble Baroness Bennett for her amendment 323B, which proposes a government review of electronic monitoring of workers in the workplace. And I agree with her that the cases that she quoted were completely unacceptable. My Lords, as noble Lords will be aware, under data protection law, employers are required to fulfil obligations as controllers if they collect and use their employees' personal data. This includes the provision of meaningful information to the workers when collecting their personal data if any decisions about them having a legal or similarly significant effect will be based solely on automatic processing. Furthermore, as noble lords know, the Data Use and Access Bill includes a range of safeguards relating to solely automated decision-making with legal and significant effects on individuals. And I'd also like to reassure noble lords that the government's plan to make work pay makes clear workers' interests will need to inform the digital transformation happening in the workplace. Our approach is to protect good jobs, ensure good future jobs, and ensure the rights and protections keep pace with the technological change. My lords, the government is committed to working with trade unions, employers, workers and experts to examine what AI and new technologies mean for work, jobs and skills. We'll promote best practice in safeguarding against the invasion of privacy through surveillance technology, spyware and discriminatory algorithmic decision-making. The plan's proposals regarding the use of AI and monitoring technology in the workplace were not included in the Employment Rights Bill to allow time for the full suite of options to be considered with proper consultation given the novel nature of AI-enabled technology. But I can assure the Noble Lord, Lord Clement Jones, that the Institute for the Future of Work will, of course, be welcome to make an input into that piece of work and that consultation which is going forward. And I would also like to reassure Noble Lords and the Noble Baroness Bennett that this is an area that the government is actively looking into, and we will consult on these make work pay proposals in due course. If I next turn to the Noble Lord, Lord Holmes of Richmond's amendments beginning with 289 and 290, the government agrees with the Noble Lord that AI should be used ethically with proper mechanisms for redress, which is why existing data protection legislation provides safeguards for solely automated decision-making with legal and significant effects on individuals, and the use of AI where personal data is processed, including in workplaces. I also thank Noble Lord Holmes for his Amendment 291, which would require workers and employers to maintain records of data and IP used in AI training and allow independent audits of AI processes. As the Noble Lord knows, this issue is under active consideration in the Data Use and Access Bill. A public consultation sponsored by DCIT, the IPO and DCMS on issues relating to copyright and AI, including questions on transparency, closed in February 2025. Transparency on the use of intellectual property material in AI training has been acknowledged in debates and government amendments as a critical issue. I committed only yesterday that the government will publish a report on the subject within 9 months of royal assent. So can I respectfully suggest that it's not helpful to have the same debate running across those two bills at the same time? In addressing Amendment 292 and 293 in the name of the Noble Lord Lord Holmes, I'm happy to reassure him that the UK's data protection framework already provides robust and effective protection for processing personal data, including for workers. Consent is a lawful ground for processing personal data, but it may not be freely given in employment contexts due to the power imbalance between the employer and the employee. That's why we would not deem it appropriate to restrict the lawful grounds on which data can be processed in this way. In addition, when processing personal data, organisations are required to notify data subjects, such as employees, of matters such as the purposes for data processing, any automated decision-making, any recipients of the data and the data subject's rights. This includes the right to object to it being processed or to restrict what can be done with it. Amendments, my lords, Amendments 294, 295 and 296 in the name of Noble Lord Lord Holmes concern the use of automated decision-making. I'd like to reaffirm that under data protection law, employers must fulfil their obligations as controllers if they collect and use employees' personal data. They must provide meaningful information to the workers when collecting their personal data if any decisions about them having a legal or similarly significant effect will be based solely on automated processing. This ensures that the workers are informed about the logic involved in the automated processing, as well as the significance and the envisaged consequences for them. The reforms in the Data Use and Access Bill include a range of safeguards after a decision about an individual has been taken based solely on automated decision-making. I hope, noble lords, and my noble friend Baroness O'Grady will be reassured that these safeguards include that the individuals receive the information about significant decisions, as well as the opportunity to make representations and to obtain human intervention. My lords, further, the government agrees that human intervention in automated decision-making should be carried out competently. The UK's data protection regulator, the ICO, has existing guidance explaining how requests for human review should be managed. When it comes to high-risk automated decision-making, the government doesn't feel it necessary to introduce an outright prohibition of processing of the nature described in Amendment 294. There are already specific requirements that apply for processing, which can result in a high risk to the rights and freedoms of individuals. Organisations must carry out an impact assessment and consult with the ICO where such an assessment indicates a high risk to individuals in the absence of effective measures. If I now turn to Amendment 298 in the name of Noble Lord Holmes, on the creation of a new regulator for the use of AI in recruitment and employment. As the Noble Lord may be aware, the previous government published guidance on responsible AI in recruitment last year, which was developed with stakeholders and relevant regulators such as the Information Commissioner's Office and the Equality and Human Rights Commission. The government, via the AI Security Institute and the Central AI Risk Function, is already processing our understanding of AI risks, including AI and its impact on the labour market. This work is being carried out across government with the involvement of each department where specific sector knowledge is valuable. And I would like to remind the Noble Lord that AI is not currently unregulated. Given the cross-cutting nature of AI, the government believes AI is best regulated at the point of use by the AI's existing sectoral regulators. As experts in their sectors, they are best placed to understand the uses and risks of AI in their relevant areas. That's why, in response to the AI Action Plan, the government has committed to supporting regulators in evaluating their AI capabilities and understanding how these can be strengthened. My Lords, as set out in our manifesto, the government is also developing legislative proposals which will allow us to safely realise the enormous benefits of the most powerful AI systems. These proposals will be highly targeted and will be designed to be future-proofed and effective against this fast-evolving technology. My Lords, we look forward to engaging further with a wide range of stakeholders on our legislative proposals, including providing clarity on where responsibility for compliance with any new rules lie. The Noble Lords have provided some interesting areas for consideration, but we're keen that these far-reaching amendments are properly assessed. But I would like to reassure the Noble Lords that this is an area the government is actively looking into. In this respect, I'm pleased to note the active engagement between my officials and stakeholders, most recently with the IPPR, whose recent report on surveillance technologies makes a helpful contribution to the awareness and understanding of this context. And as already mentioned, we intend to consult on these Make Work Pay proposals in due course. Furthermore, I'd like to remind Noble Lords that in response to the AI Action Plan, the government has committed to supporting regulators in evaluating their AI capabilities and understanding how these can be strengthened. Finally, I'd like to thank my Noble Lords for their interest in how AI is being adopted in the workplace and the helpful way that they have focused on these issues. And I would like to also to reassure my noble friend Baroness O'Grady that we're working with the relevant stakeholders to build a strong evidence base to tackle these 21st century challenges relating to these technologies. Our public consultation will be a crucial part of future-proofing the proposals. So I hope I can assure Noble Lords that the Government is committed to making sure that workers' interests inform the digital transformation taking place in the workplace. And I therefore ask the Noble Lord Clement Jones to withdraw his Amendment 148.
Thank the Minister. I think that's probably the most comprehensive statement about the government's intentions on AI regulation that I've heard in this Parliament. So I really do thank her and her officials for taking the time and trouble to set out their approach. And, the Noble Lord Sharp talked about gap analysis, and I'm very much in favour of that. I don't want to see duplication of regulation. I want to see effective regulation. And the challenge was set out by the Noble Baroness O'Grady. Will the government address the new challenges? And that seems to me to be absolutely at the heart of this, my lords. And I thank her for her assurance that there is going to be an imminent consultation. And I think all of us with an interest in this will very much want to take part in that. And I hope that, in a way, this mini-debate has started the ball rolling and getting people's thoughts about what we can do. And I thought what the Noble Baroness Bennett had to say was absolutely crucial. I thought the illustrations that she gave were exactly why we're concerned about these issues, my lords. I helped to, when talking of gap analysis, I helped to launch the new ICO AI and biometric strategy this morning, my lords. Now, all of us are a little bit nervous about this because we don't think that the current ICO regime does cover all the issues relating to AI use, particularly in the workplace. And we're subject to exactly the issues that the Noble Lord Holmes put his finger on. There is no appetite for cross-sectoral regulation, my lords, in this government. But what does that mean? That we have to pick off individual sectors, sector by sector, only to be told on individual bills, no, I'm sorry, it's not appropriate to start legislating about AI in our particular bit of legislation. And the Noble Baroness, notably, I notice, and I just certainly don't want to raise the issues again, fell back on the Data Use and Access Bill again, my lords. And we had many debates about automated decision-making and so on. I don't believe that regime going forward will be adequate, my lords. I very much hope that the consultation will deal with all the issues well beyond the gig economy, as the Noble Baroness O'Grady talked about, surveillance, right to human review, and so on. And I listened very intently to what the Noble Lord Sharp had to say, which actually in many ways was more sympathetic to this form of regulation than I expected. But I do not really believe, my lords, that there should be this kind of juxtaposition between vigilance versus regulatory restraint, my lords. There's a kind of St. Augustinian approach to regulation, which I'm afraid I don't share. But anyway, I beg to withdraw my Amendment 148.
Your Lordship's pleasure, this amendment be withdrawn. Amendment is by leave withdrawn. Amendment 149, Lord Clement Jones, not moved. Amendment 150, not moved. We now come to the next group. I must inform the House that if amendment... Sorry? Oh, the question is that Clause 35 stand part of the bill. As many of that opinion should say content. The contrary not content, the contents have it. Before we come to the next group, I must inform the House that if Amendment 151 is agreed to, I will not be able to call Amendments 152 to 158 for reason of preemption. So in Schedule 4, Amendment 151, Baroness Barron.
My Lords, I rise to speak to Amendments 151, 174 and 180 in my name. These amendments address one of the most crucial challenges in our education system, how we value, support and compensate more than half of the school workforce, the non-teaching staff. These teaching assistants, business managers, IT technicians, cleaners and catering staff form the backbone of every successful school. And while the government's intention to establish a school support staff negotiating body demonstrates a genuine commitment to these vital employees and indeed fulfills the manifesto pledge, I'm really concerned that the proposals as drafted are unworkable, expensive and time-consuming, that they will add to the complexity and workload of every single school, not just academies. Individual maintained schools will often not be aware that the pay structure in their local authority is different to that in a neighbouring one. My amendments focus on academy schools, but the thrust of my argument to the government is to think again because of the impact on every single school. My Amendment 151 seeks to mitigate potential damage by limiting the SSNB's powers to creating a framework that academies must consider regarding remuneration, terms and conditions, training, career progression and related matters. And I believe that these flexibilities should extend to maintained schools as well. My Amendment 174 requires the government to produce an impact assessment before introducing these changes of the cost to the whole education sector, both academies and maintained schools. And my Amendment 180 requires the annual reports of the SSNB to include an assessment of the increased costs of any pay and conditions agreements to the sector. It is important, my lords, that we are really clear what we mean by support staff. Support staff are not a homogenous group, but an extraordinarily diverse workforce spanning many different roles, skill levels and contexts. Teaching assistants, while crucial, comprise less than half of all support staff. The remainder includes roles ranging from pastoral care to facilities managers, finance assistants, network administrators and school receptionists. A small maintained primary school might employ a part-time administrative assistant handling multiple responsibilities, while a large multi-academy trust might maintain specialised finance teams, HR professionals and IT specialists serving multiple schools across a region. This diversity is intentional and beneficial. Schools and trusts have developed different approaches to organising their support functions because they face varying challenges, they serve distinct communities and operate at very different scales. What serves a 100-pupil rural primary school won't suit a 2,000-pupil secondary academy, and what works for a standalone school won't fit a trust operating across multiple regions. And any national framework that fails to acknowledge this reality risks becoming either too vague to be useful or too rigid to serve communities effectively. I'm not trying to suggest, my lords, that the status quo is perfect. The current National Joint Council arrangements have significant weaknesses in their application to schools, leading some local authorities, such as those in the so-called London Fringe, to opt out of the Green Book terms and conditions entirely. Firstly, the NJC terms and conditions were designed for general local government workers, from refuse collectors to office administrators, but they barely address the school's specific working environment and unique demands. Secondly, I would argue that there's insufficient coordination today between teacher and support staff pay negotiations. These separate processes often reach conflicting conclusions about affordability and appropriate pay increases, and I wondered whether the Noble Baroness the Minister had considered expanding the remit of the STRB to include support staff. Thirdly, the Department for Education has minimal influence over support staff pay decisions, and the school affordability is not factored into NJC decision-making. Consequently, when resources are limited, teachers' pay becomes the residual after other decisions are made, which is clearly an extraordinary outcome. The current legislative approach is fundamentally flawed. Mandating a single detailed set of terms and conditions for all support staff will create more problems than it solves, excuse me, and certainly won't address the challenges schools face with recruitment and retention. Firstly, it's essentially impossible to have a national set of pay scales for this very wide range of roles, given the vast variation in how schools and trusts organise their functions and their work. Consider this example. How can one write a generic job description for a finance assistant that serves both a small primary school's sole financial administrator and a large trust specialist management accountant? Though sharing a title, these roles require entirely different skills, qualifications and responsibilities. What schools do for themselves and what is done by their local authority or a trust central team varies hugely across the country. How many people there are to run finance or technology in a school, and therefore their seniority and skill, depends on the size of the school and on its legal status. Secondly, at present, under the NJC, each local authority sets its own grading structure. So even if you could find a role which was commonly defined across the country, you would find that it was graded and paid somewhat differently in different areas. So the SSSNB would be expected to override these 150 grading structures and produce one national one. This would inevitably entail paying some people more at potentially substantial cost in some areas, or paying some people less. And I would argue that neither outcome is really palatable. Furthermore, much of this variation is driven by local labour markets. Some areas have to pay more than others to get decent IT skills, for example. It would be extraordinary to require schools in Cambridge to pay the same for IT skills as other schools if it meant that they couldn't get the skilled people they needed, or that other schools had to pay significantly more than they do now. I've also heard ministers suggest that their aim is to create a floor, not a ceiling, which is to say the creation of a pay floor. But that does not change the fundamental problem. It represents a full pay negotiation beyond NJC agreements, and therefore an effective national grading structure in which roles are mapped to a national spine in a consistent way across the country, rather than the more than 150 ways that currently exist. The task of trying to do that could only be begun after considering every local variation that exists. The floor points negotiation faces another challenge. Employers can't afford floors above current pay rates, plus the cost of living adjustments, and understandably, unions won't accept anything lower, even as a minimum. And given that the same role currently receives different pay across local authorities within the NJC, achieving both goals everywhere is impossible. So I hope that the Noble Baroness, the Minister, would acknowledge that this will create complications for local authorities. Their grading structures likely won't align with the nationally mandated school support staff pay scales. So must authorities alter their grading structure to match the national framework, or will they apply it only to schools, or neither? Every possible answer creates serious problems of complexity and comparability within individual local authorities. Most concerning is that this fiendishly complicated approach addresses non-existent problems. Despite repeated allegations of academies cutting and poaching support staff, sector colleagues can find no evidence of this. And indeed, I find it hard to imagine any rational person who would take a cut in their salary to be poached. In fact, academies that have departed from standard terms and conditions have done so to enhance pay, improve conditions, improve career prospects, and not reduce them. And claims that support staff lack clear contractual terms are just not correct. Like teachers, they have specific contracts, often referencing established national or local frameworks. The contractual arrangements is not the issue. My Lords, our school support staff deserve recognition, proper pay, good working conditions and career development opportunities. And above all, they need a policy framework that serves both them and their schools effectively. We can build this through pragmatic reform, building on existing strengths, addressing real weaknesses, and respecting the diversity and complexity of modern school organisations. But we cannot achieve meaningful improvement through legislation that ignores schools' practical operations and imposes uniformity where variety better serves everyone. My amendments make some progress towards this goal, and I would strongly urge the Noble Baroness the Minister to reconsider the Government's approach. I beg to move.
Amendment proposed in Schedule 4, page 195, leave out from line 3 to line 18 and insert the words as printed in the Marshall list.
My Lords, I rise to speak to the amendment in my name, but I'll start by fully endorsing what my noble friend Baroness Barron has just said. Her experience directly on this, I think, is worth the government reflecting on when it comes to consideration as we move to report stage. My amendment is quite simple. It's actually more of a practice, convention, whatever it is that we get into primary legislation. Candidly, I object to the naming of an organisation that is not actually a regulator in this country. It's not, that needs to be consulted by the Secretary of State. The Secretary of State can consult anybody they like when they're considering making regulations. I don't see why the TUC should be named in primary legislation as a consequence of doing it. And that's the reason why I think it's poor legislation and doesn't add anything to the bill.
My Lord, can I rise to support my noble friend Lady Barron in her amendments? I'm just genuinely rather confused by how this is going to improve the education system. And I just speak from someone in the front line. As of today, my Academy Trust employs 717 non-teaching staff across our 18 schools. We provide high-quality benefits to our staff. We have to match the terms and conditions of the local authority, including the very generous pension. And indeed, we're proud to do that. But we go much further than that as well. For example, we offer a health scheme for all of our staff, both teaching and non-teaching, which provides an online consultation to a GP, online access to prescriptions so that they are able to get treatment far more quickly than the backlog that exists in the NHS. We provide a dental scheme, which again gives access to, I think, to one hygienist appointment a year. We provide theatre discounts and retail discounts. On top of that, we have been very assertive in pushing through apprenticeships for our non-teaching staff. We have put nearly 69 staff through apprenticeships over the last couple of years, which I think is a pretty high percentage relative to the 700 odd that we employ. We did that knowing full well that we would lose a lot of those staff because they became skilled to go on and move to jobs elsewhere, which is what they've done. So, my Lords, my question to the Minister is really, how does this improve anything for teaching? It'll add another layer of administration and cost. We'll have to have more HR resource deployed to wade our way through these regulations. They sound extraordinarily impractical, listening to Lady Barron, because, frankly, an IT support staff member in, say, Thetford, where we have our most westerly school, is a very different market to anything going on in Cambridge. And indeed, what is an IT role? The role is changing almost monthly at the moment as we try to create data lakes to access large language models for our own teaching data. These things are undefined, so you'll have to create bands that are so wide as to be meaningless. And to Lady Barron's point, we can't afford to go higher and we can't go lower, so what is the point of all this? So I would be grateful for the Minister's comments.
Lords, I speak in favour of the proposed school support staff negotiating body as set out in the bill. If you remember, back in, I believe, 2010, the schools negotiating body was established. All of the things that has been said in this chamber today were talked about prior to the establishment of the schools negotiating body, the support staff negotiating body in 2010. Now, unfortunately, there was a change of government. A coalition came in, and even though the school staff negotiating body had met once and everything set up, the arguments dealt with, moving forward, something we had great hope in, despite all of that, the coalition's first act was to abolish it. And so here today, with looking at the Employment Rights Bill, we're in a position where we can rectify something which was wrong in the first place. The new body that is being talked about in the Employment Rights Bill, long overdue, would work towards a number of goals for support staff, some of which have already been mentioned. But it would give support staff a voice in the education debate. It would achieve fair pay, something which is the law of this land. It would create a unified pay and conditions across the country. What's so wrong with that? When we look at local government, and local government has been mentioned, it negotiates on behalf of millions and millions of local government workers doing far different jobs in far different places in our communities with different arrangements in place to meet the local conditions where the service is being provided. All of that has been in place for not just decades, but for a century. And again, you look at our National Health Service, and we all applaud the joint working. We all applaud the way in which pay and conditions and fair pay for work of equal value has been implemented across our NHS and all the different disciplines that the NHS provides in our communities. And that has been done. And it's been done, and collective bargaining works well. And the issues that may have to be addressed, they are addressed in those bodies, and they are dealt with as we actually move forward. So we're talking about a group of staff within schools that for many, many years have seen teachers have all the collective bargaining which they undertake, which we obviously support. But we see the other staff within the schools having nothing, at the whim of the headmaster or headmistress, at the whim of local surroundings, and little is done on their behalf. And that's why school staff, support staff across the country are welcoming the establishment or the re-establishment of the school staff, support staff negotiating body. I'd just also like to add about the TUC itself. And my starting point is it's a voice for the good. It's at the heart of the trade union movement. It's held in respect by employers and by governments alike. And if there are differences, if there are issues that need to be tackled, why not go to the heart of the trade union movement and ask for their advice and for their assistance? It's been doing it for nearly 100 years, and it's been doing it well, and there's no reason whatsoever why it cannot be part of the arrangements for establishing the new body. So I'm proud of the work that the TUC does. Sorry?
The noble Lord for giving way. What I was being quite clear about is the Secretary of State could consult whoever they like, and I wouldn't be surprised if they consulted the TUC. My point is, in terms of legislation, why is this being put into the primary legislation, into the Act, when it's completely unneeded?
Thank you for that comment. If I may conclude, the whole intention appears to be to limit the scope of any collective bargaining. It's as clear as day. We can come up with all the words about different involvement and who should clear what and who should do the other. It delays things, and that is the intention of the amendments that we have before us. I do want to make it clear that We, as people within this chamber, looking at the proposals, I mean, we've got to understand that the proposals do legislate for the Secretary of State or their nominees to be involved in the negotiating body. And I personally have got no reservations about that. We want to talk to the people who've got the power and the influence to actually make decisions that improves the service and the teaching in our school. And this amendment, or this proposal of the new body, it's actually intended to improve schools. It's intended to help improve education in our schools. And what better way of doing it than to bring people together, give them a voice and allow their voice to be heard and to come to conclusions which are for the benefit of all. Thank you.
Well, my lords, I think this has been a very important debate, and I thank my noble friends, Baroness Barron and Baroness Coffey, for their amendments in this group. And I think we've had some very interesting real-life examples given by my noble friend, Lord Agnew of Oulton, and also an important dimension from Lord Prentice of Leeds, to which I will return in just one moment. I am, however, pleased to speak in support of Amendment 151, introduced by my noble friend Baroness Barron. This amendment highlights an essential but often underappreciated part of our school workforce, the support staff. And that is where I would agree with Lord Prentice of Leeds. Those support staff keep schools running smoothly every day. From teaching assistants to catering teams, their work is vital, and as my noble friend put it, they form the backbone of the whole system. Now, the government's bill takes a step forward by proposing the creation of a school support staff negotiating body. And I make it clear, I believe that is a welcome move. However, the current approach of the bill, with its push for a single set of national pay and conditions, risks overlooking the real differences which exist between schools. As my noble friend Lord Agnew of Oulton pointed out, especially between maintained schools and academies. What this amendment does so well is to recognise the need for a flexible framework for academies, one that they must consider and may depart from only in exceptional circumstances. This respects academies' independence while still promoting fairness and consistency. We must, of course, remember that support staff is a broad term covering a wide range of roles and responsibilities. The needs of a small primary school and a large multi-academy trust are not at all the same. And any framework has to reflect that diversity. Well, like in most areas